Hi everyone, let's talk about personal property and bailments. In this lesson, we'll define what personal property is. We'll describe the methods for acquiring and transferring ownership in personal property. We'll differentiate ownership rights in mislaid, lost, and abandoned property. We'll define what a bailment is and describe the elements of one. And then we'll look at various types of bailments. Jumping right in, let's do a quick primer on different kinds of property, or at least different vocabulary regarding property. So property is things that people can own, people being natural people as well as artificial people, businesses, and the like. So we can broadly take property divided up into two categories, one being real property, the other being personal property. Real property is land and things that are attached to the land, like buildings and trees and stuff like that. Personal property is everything else. Everything else that's not real property would be personal property. So we can further divide things up into categories: tangible and intangible property. Now, tangible property does include real property as well, but let's focus on personal property for a second. When thinking about personal property, the tangible personal property is all the stuff that you see around you that can be picked up and moved around. Okay, so the things that aren't permanently attached to your house or to the building would be tangible personal property. Intangible personal property, things that don't necessarily have a physical form. So things like stocks, bonds, intellectual property, so copyrights, patents, trademarks, trade secrets. These are all still property, still have very real ownership rights, but can't necessarily be physically seen and touched, grabbed, and moved around. So, just like what we were saying earlier, tangible property does include real property as well, but speaking about personal property specifically here, it is the property that has substance and can be touched. It has other names. You can call it goods. An older word that we used to call was chattel. It just means property that you own and again can be usually picked up and moved around if it's the personal property. Intangible property, again, the rights can't necessarily be reduced to physical form, but they still do have real legal and ownership implications. Sometimes personal tangible property can become part of real property if it's permanently attached to a building or some land. So you think about maybe some kind of appliances that are screwed in and permanently attached to a house, like an HVAC unit, flooring, things that you're screwing into the wall. They become what we would call fixtures if it's permanently attached to the house, and if you can't easily remove it without causing some kind of damage to the real property, then it becomes part of the real property. So thus, if I was to sell my house, the things that are fixtures we would expect would transfer with the sale. And if I don't want those fixtures to transfer with the sale, we should agree to that ahead of time, just so both parties, the buyer and the seller, know what to expect out of the transaction. Okay, so the methods of acquiring ownership in personal property. I just give you a list here, and then so you can get an idea of what we're going to be talking about, and then we'll discuss each one in a little bit more detail. But you have possession or capture, you have purchase, production, gift, accession, confusion, will, living, trust, or inheritance, and then divorce or annulment. These are all methods by which somebody could acquire ownership of personal property. So taking them one by one. Possession or capture. Acquiring ownership in unowned personal property. Now, this doesn't happen very often in an industrialized nation where most of the land has been claimed either by natural people or by the government or by corporations or whatever. You don't often just see property out there that is unowned that you can acquire. I can't just go to somebody else's land and claim ownership of it because it's already owned by somebody. But if property is abandoned, we'll learn later. For instance, somebody leaves something out by a dumpster or something like that, indicating that they don't want it anymore and it's no longer owned by anyone, then I can go take possession of that property. One of the most common ways to acquire personal property is to buy it. That's what purchase means. So I just buy that personal property and the ownership rights from the other owner. Now I'm the owner. I can also acquire ownership by production, meaning I am making something. I'm taking some assortment of raw materials and producing some type of finished product. And when I create it, I own it. I can also have things gifted to me, and I can gift things to other people. This is me just voluntarily transferring title to property without any expectation of payment to somebody else. Now it's theirs once the gift has been completed. A little bit of vocabulary. The person who gives the gift is a donor. The person who receives the gift is the donee. Talking about gifts a little bit. So we'll dive a little bit more deeply into those because there are some things to understand. One is to understand the elements. There are 3 elements of a valid gift. One is that we need to have donative intent. So the person giving the gift has to intend to transfer ownership to another person. This can be expressly stated. I'm giving this to you. It can be inferred from the behavior of somebody. Just walking something over to somebody else and handing it to them sometimes is sufficient depending on the circumstances. So it can be expressly stated or inferred from the circumstances. So we have the donative intent. Then we have to have delivery. So we actually have to give the thing to the other person. The most common form is to physically deliver it to them. So I'm taking the thing and I'm bringing it over to them and giving it to them. Or they're coming over and they're taking it back with them. Sometimes that's either impossible or it might be impractical if the thing is large and heavy to move, or if it doesn't have a physical presence necessarily. So there also exists constructive or symbolic delivery, and this is often sufficient when physical is impossible or impractical, like I said. So something like me having a safe deposit box and wanting to gift the contents to somebody else. So maybe I just give them the key to the box, and that symbolic gesture, I haven't given them the box yet, but I've given them a symbol that symbolizes the ownership of those contents. And maybe that's enough to notify and allow a court to say, yes, he intended to deliver this to the person. So element number 1, donative intent. Element number 2, delivery. Element number 3, acceptance. The donee should accept the gift. Most do, because if somebody gives you something, it's just common practice to accept it. Who doesn't want free stuff? But maybe you don't. You don't have to accept it. Nobody can force you to take something that you don't have some obligation to. So if you don't want the gift, you can refuse it, and then you're not burdened with the ownership of that thing. Going a little further on gifts, we can classify gifts into 2 major categories. Each gift will be either made during a person's lifetime, or sometimes they're made in contemplation of a person's death. So a gift inter vivos is a gift that is made during a person's lifetime that is an irrevocable present transfer of ownership. So once I have completed those 3 elements, I intend to give something, I deliver it, and they accept it. Now that gift is irrevocable or irrevocable, however you want to pronounce that word. Either way is fine. That means that I can't then go demand that thing back. I can ask for it back, and maybe they choose to give it back to me. But if I take them to court and try to sue for them to return it, I probably don't have a case there at all, unless there's some weird circumstances happening. So that's gift inter vivos. A gift causa mortis is a gift made in contemplation of death. Common scenarios: I'm on my deathbed anticipating that I will die soon, or I'm going into surgery and I give something just in case I die while I'm under. So These do happen sometimes. There are some interesting things about these gifts made in contemplation of death. They take precedence over a prior conflicting will. So even if I had a will, let's say I have a really expensive diamond ring, and I'm about to go into surgery, and I have my brother there with me who's taking good care of me, and I say, you know what, if I die while I'm in surgery, I want you to have this ring. Even if I, in my will, had promised that ring to somebody else, this gift causa mortis would take precedence over that, and my brother would have rights to it. Now, having said that, this is a gift that I can revoke at any point prior to my death. So if I actually don't die in surgery, then I can revoke that gift. Or if I just change my mind prior to actually going into surgery, then that's completely fine. It can be revoked prior up any point up to death, or if death doesn't occur in the way that I thought it was going to, then that gift can be revoked. So establishing a gift causa mortis. So one element is that the donor makes a gift in anticipation of approaching death, and that the donor actually dies without having revoked the gift. And then if you want to get really technical about it, sometimes the circumstances dictate that the donor dies from the specific cause they were anticipating at the time. So that can make a difference sometimes, just depending on what's going on. Okay. Speaking about gifts a little more, I know there's a lot here about gifts, but, because there's a lot of stuff about them. So one of the things here is we were finding out that especially people that had some wealth about them were finding ways of trying to dodge taxes in every way they could possibly. And one of the things they would do is just give a bunch of money to their kids or, young relatives who don't really have a taxable income. And that way that money is taxed at a much lower rate. And the gift wasn't really a good faith gift. It was really more of them just sort of stashing money away with young family members so that they wouldn't have to pay tax on it. Okay. So this necessitated the passage of some legislation to create some rules around giving money to minors. So we have an older version, the Uniform Gifts to Minors Act, and then a newer version, the Uniform Transfers to Minors Act, or the UTMA. The UTMA can be found in North Carolina statutes, and I've given you a link there. But it basically just establishes procedures for adults to make gifts of money and securities, stocks, bonds, to minors. And then it sets rules around, how much of that will have some type of tax advantage. Okay. And not all of it. Okay. But within certain limits, there will be a certain low-level amount of tax advantage to gifting money or securities to minors. Another way of acquiring ownership is through accession. This is the increase in the value of personal property as it is added to or improved by either natural or manufactured means. So one way value can be added by natural means is, let's say I have a sheep, and then that sheep gives birth to additional sheep. Now my value has increased because now I have multiple sheep instead of just one. So that is accession. You could also have manufactured means if people are adding things to some piece of equipment or whatever that increases its value in some way. We would call that accession. Ownership can also happen through confusion, which has a pretty specific definition here. Here, what we're talking about is if fungible goods are co-mingled. Let's back up for a second, talk about what a fungible good is. A fungible good just means usually dealing with commodities. So let's say something like wheat. Okay, I have 5 bushels of wheat. You have 2 bushels of wheat. If they're the same quality of wheat, and if they get mixed together, it doesn't really matter which bushels are whose. It just matters that we know who owns the amount of bushels for us to understand the ownership rights in that mixed batch there. So that's a fungible good. So when we take fungible goods, commingle them, so mix them up together. Maybe I have oil, you have oil. We mix it up into one large container to be shipped across the country and to be sold. So it doesn't matter. They get mixed up as long as it's the same quality of oil. The owners are going to share title in proportion to the amount of goods they contributed. So if I owned half, you owned half, then we have 50-50 ownership, and it doesn't matter if it's the oil that comes out first, the oil comes out last, whatever. That's the definition of confusion here for this specific context. Okay, so we can also acquire property through wills, trusts, inheritances, divorces, or annulments. So let's take wills, living trusts, and inheritances first. This is property that's distributed according to, now hopefully, and this is a good idea for everybody, and you can, study a lot more about estate planning, but one of the best things you can do for your family is to create a good plan ahead of time for what would happen in the event of your death. This becomes much more important as you get married and have kids and there's people depending on you and stuff like that. So it's a good idea to have a will in place. And then part of that, you can create trusts. You can, depending on how much wealth you have, maybe that makes sense, maybe it doesn't. But property that's distributed according to named beneficiaries in a will or living trust, that property then becomes owned by them. If a person dies without having executed a will, we would call that person intestate. They've died without a last will and testament. Then the property is distributed as provided in your state's inheritance statute. So I give you a link to North Carolina's intestate statute, so you can go read more about how property is distributed. It basically boils down to the people who are most closely related to you get the most, and then if you can't find these people, then it starts being distributed out to more and more distant family members. So it's fairly logical. But if you don't want it to go that way, then it's important to have a will that states exactly how the property should be distributed. And then, of course, marriages, we have a very high divorce rate in our country. It's very common for people to get divorced. No judgments there. It happens. You know what? Sometimes you're better off. But when two people have been married, especially if they've been married for a long time, then there's been a lot of property acquired, oftentimes, within that marriage. And then we have to figure out how the property is going to be distributed once the people go their separate ways. So usually this is settled in a settlement agreement, a divorce settlement agreement. So we say, okay, our attorneys, either we sit down and hash it out ourselves or our attorneys do it for us and figure out who gets what. If we are unable to arrive at a settlement, then the court would have to step in and decide what those property rights are going to be. I hope none of you have to go through this because from what I've heard, it sounds like a miserable experience, but life is life. Okay, switching gears. Mislaid, lost, and abandoned property. There can be technical differences regarding the old finders keepers rule that we all stated on the playground when we were younger. It's not always finders keepers. Sometimes it is. Understanding the nature of the property that we found can be pretty important. So that's what this discussion is all about. So let's define the terms here. So mislaid property. Okay. Mislaid property means that somebody set something somewhere and then they just forgot about it and left. They didn't intend to not have this thing anymore. So an example, if I go to a restaurant, I go to the bathroom, and then for some reason I set my wallet on the sink while I'm washing my hands, and I forget my wallet and I just walk away. I didn't intend to not have my wallet anymore. I just laid it down there and I forgot about it. Now, when I discover that I've left it somewhere, I'm probably going to come back and look for it and try to find it. So I voluntarily left it somewhere, forgot about it. If somebody finds it, they're not automatically entitled to possession and ownership of my wallet. What they should do, hopefully, if they're a very nice person, is leave it with the owner of the premises where it's found. And then they could make some reasonable effort to try to let me know that it's there, or at least take reasonable care of it until I come back to try to find it. Now, what you'll notice here is that what if a person just takes it and walks away? Well, there's a really good chance I never find that person and we never know about it. But what we're talking about here is scenarios where we have honest people who are stating what happened and trying to decide who actually owns what. And these are the technical rules here. So, lost property. Now, this is due to an owner leaving some property somewhere due to either negligence or carelessness or inadvertence. So this could be something as simple as I'm walking down the street and I didn't put my wallet in my pants all the way, so it was kind of halfway hanging out, and as I'm walking, it just falls out. Or maybe I had it in my jacket pocket and I'm carrying my jacket in my hands, and my wallet or my phone just fall out, and now they're laying in the street and I'm walking away having no idea that I just lost something that's very important to me. And then somebody comes along and finds it. Do they automatically own it? The answer is no. And again, we have to assume that we're dealing with honest people here, because it's very hard to find people if they just grab something and walk away. Although, having said that, with phones, it's becoming much, much easier to track those down. So anyway, let's say that I've lost my phone. Let's use a phone, for example. It's a good example. Somebody comes along and finds it. They think that they own it because it was laying there and they found it. But legally, what really should be happening is they should try to return the property if they can. If either one of us finds one another, if they find me or if I find them, they should return the lost property, and they aren't necessarily entitled to anything in return. Although if I go out there and post a reward for returning of lost property, then I have the obligation to if somebody gives it back to me. Okay, so if, let's say I lost my phone, somebody found it, and I'm able to track that phone down, and then I go to them and I say, hey, you have my phone, I would like it back. And they say, nope, I found this, it's mine. The legal rule is that they have the obligation to return it to me. If they refuse to do that, then that can make them liable for the tort of conversion and possibly the crime of larceny. They have property that's not theirs and they're refusing it to return it to the owner. Some states, this kind of depends on where you live. Maybe you have some obligation to actually actively do something. There used to be requirements that you run like an ad in the newspaper or something saying this item has been lost, things like that. That really just kind of depends on where you live. Abandoned property, this is different. This is different. Now I'm discarding something intentionally, and I no longer want to own this thing. So, examples, me carrying something out and laying it next to a dumpster sort of indicates that I'm no longer interested in owning this thing anymore. If I take an old couch out there and leave it by the dumpster. Or if I take something out of my house and leave it by the curb, that tends to be sort of a universal sign that if anybody comes along and sees that stuff laying by the dumpster or by the curb, then they're free to take it and now it's theirs. That's abandoned property. So somebody who comes across abandoned property, they are actually entitled to ownership of that thing. The finder acquires title to the property against the rights of everyone, even the original owner. Now, sometimes there are blurry lines between whether something has been abandoned or if it was lost, and maybe the court has to step in and try to analyze the circumstances to find out what's going on. But once they make a determination about whether or not it's abandoned or lost, it can make a big difference in who actually owns it. Some states have estray statutes. This, again, will depend on where you live, but that would be a statute that permits a finder of mislaid or lost property to clear title of the property if certain legal formalities are met. So this is the kind of statute that says you have to run an ad in the newspaper or whatever it would be to at least make a reasonable effort to try to find the owner. And then oftentimes there will be a period of time. Once that period of time elapses, then you're entitled to ownership of that property. So here's a case to illustrate how those lines can be blurry sometimes between mislaid or abandoned property. So this is Grand versus Jennings. It happened in Arizona in 2012. The basic idea is that we had a man who was known to hide property and valuables around his property. So, think about storing cash in jars and then burying them, or just hiding them, hiding gold, hiding jewelry. And his daughters were aware of this. So after he died, they went around the house and found whatever they could of the stuff that he had hidden in his own house. And they thought that they had found everything. So then they sold the house to somebody else. Now that somebody else hired a remodeler to come in and do some work on the house. Now they started opening up walls in the house, and they found some ammunition boxes stuffed with cash to the tune of $500,000. Now the laborer who found this turned it over to his business owner, his supervisor, who happened to be the business owner, and the business owner took possession of it, claiming that it was his because he found it. The owners of the house thought, no, this is our house, and you found it in our house, so it's ours. And then the daughters of the man who hid the money said that, no, it's actually ours because our father mislaid it, and it still is owned by us. So the court had to try to go in and figure out who actually owns this property. Now, this is a pretty common kind of dispute when you find some money or some valuables somewhere. So what the court decided was that it wasn't abandoned, because you generally don't abandon cash. It's generally the presumption that people wouldn't voluntarily just leave cash somewhere and walk away intending to not have it anymore. So it's more appropriately labeled as being mislaid. And since it was mislaid property, then the original owners or the original owner would have been the man. And then since the property would go into his estate, that his estate is actually the rightful owner of that cash. So it would go into his estate and then be distributed out to his heirs. A bailment. This might be a word you've never encountered before, but you've encountered the relationship multiple times in your life, even if you're young. Everybody's well familiar with bailments, even if they don't know the term. This is the definition here, is a transaction in which an owner transfers their personal property to another person to be held, stored, delivered, or for some other purpose. The basic idea is that I'm taking my property that I own, I'm delivering possession of it to somebody else, but I'm not intending that they own it. They're just going to have it for a little bit. I'm either letting them borrow it or I'm paying them to hold it for me, or whatever the relationship might be. Then the idea would be later that I get that property back. So the bailor is the party that owns the property and transfers it to somebody else in the bailment. The bailee is the person to whom the property is delivered. So little graph for you. This may or may not be helpful, but the bailor transfers goods, some type of property, to a bailee for one reason or another, without the bailee owning the property. Okay, so the elements to create a bailment. So only personal property can be bailed. So let's say that from the get-go. We have to have delivery of possession. So the bailee must have exclusive control over the property, and the bailee must knowingly accept the property. So an example here. If I'm going out of town, so me and my wife are going on a trip for Thanksgiving, and we need somebody to watch our dogs while we're gone. So I could just ask my neighbor, hey, will you watch my dogs for me? And they might voluntarily agree, or I might pay them to do it for me. So I'm not giving them my dogs. They don't own them. They're just watching them while I'm gone. And then when I come back, they'll return them back to me. So if they agree to this, this is perfectly fine. And we have a bailment. But I can't just show up, dump my dogs at their house, and then run away as fast as I can, and then they have any kind of legal obligation to do anything. They have to knowingly accept. If they don't accept it, then the bailment doesn't exist. We also are going to have some type of bailment agreement. This can be expressly stated or it can be implied. So express bailments can be written or oral, just general agreements that I have with my neighbors, for instance, would just be oral. We're not writing down terms of a bailment here. It's just, hey, I'll be back in 2 days. Will you watch my dogs? That's completely fine. Now, having said that, if we're dealing with a bailment where money is involved, maybe it's a good idea to have that written down. And if the terms of the bailment are going to last longer than a year, in order for it to have any legal weight, then it should be written down in order to satisfy the statute of frauds, because that's one of those, a contract lasting longer than a year that can't be completed within a year should be written to be enforceable. We studied that maybe in Business Law 1. I can't remember when we studied that exactly. And then you have implied bailments. So an example, even though we don't have any kind of agreement about the bailment, it could be implied. For instance, somebody lost some property. I found it. Now I have possession, but I don't have legal ownership or title to that property. So I have some legal obligation to safeguard it within some period of time, and then turn it over to the original owner if I can find them. So this is an interesting case. Ziva Jewelry Incorporated versus Car Wash Headquarters Incorporated. This happened in Alabama in 2004. But Ziva was a salesman for a jewelry company. Or actually, Ziva was the jewelry company, and they had a salesman who was driving his own personal car, and it was common for him to use his own personal car to drive back and forth between shows and wherever you would transport jewelry. He had $850,000 worth of jewelry in the trunk of his car, and he stopped at a car wash to get his car washed. So it's one of those places where you drop the car off and then you go into a waiting area, and then as soon as they're done, you would go out and get in your car and drive away. So he was in the waiting area. He saw that they were done with his car. They gave him a wave. He goes up to pay, and in the time that he's paying, somebody else jumps in his car and takes off. They find the car pretty soon after they call the police, but the jewelry was gone. So Ziva Jewelry, that is the owner of the jewelry, they are suing the car wash company, saying that they need to be reimbursed $850,000 for that jewelry that's lost. So the court has to try to figure out, was there actually a bailment here? Is Ziva going to be able to recover from car wash? So was car wash liable for that $850,000 worth of jewelry? So the court looked at it and said, well, the car wash had no idea that they were taking care of that amount of money worth of jewelry in the trunk of this car. They had no idea. They just thought they were washing a car. Maybe they had bailment of the car for a limited period of time, and until they turned it back over to the owner after he paid. But since they didn't know, they weren't able to knowingly accept the terms of this bailment here because they had no idea about that jewelry. So that they weren't going to be liable for that amount. So Ziva Jewelry is going to have to take that loss. In reality, they may have to just go through their insurance to try to get reimbursement for it. If they have insurance, hopefully they do. So a few types of, we'll start off with ordinary bailments, and then we'll go over some special cases. But we can take ordinary bailments and we can break them up into two categories. One category is gratuitous bailments. These are for the sole benefit of one party or the other. So they can be for a sole benefit of the bailor or a sole benefit of the bailee. And we'll get down into the nitty gritty a little bit more here in a second. And then the other category is mutual benefit bailments, where both parties are getting something. So starting, we'll say gratuitous bailment, property transferred to another person without either parties giving or asking for any payment of any kind. And since we're not giving or asking for any payment from one party, then they lack consideration. So this type of agreement can be rescinded at any time by either party. Let's talk about them specifically. So taking one example first, the bailment for the sole benefit of the bailor. This is a gratuitous bailment that benefits only the bailor. An example would be asking a friend to watch my car while I'm out of town, and then just doing it because they're a nice person and they're not, I'm not paying them. They're not expecting me to pay them. I'm the only one who benefits out of this. Now, the common law rule here is that they would owe only a duty of slight care, not to be grossly negligent in caring for the bailed goods. Why do we even mention this? Because what if something happens to my car while my neighbor is watching it? They were doing me a favor. They were watching my car. Let's say a tree fell on my car or something. Do they owe me for the damages to my car? And it can depend on the circumstances. And then under common law, so common law is the older version, and then later on states pass specific rules. So what would be the rule guarding your transaction really depends on where you live and what you say in your agreement. So I'm going to give you these common law rules, and you just have to understand that your specific rules might be different according to where you live and what rules are applied there. And then if you have a bailment agreement, what are stated in the terms of that agreement. So that's a lot of exceptions and caveats there, but here we go. Since it's only for the benefit of the bailor, in this case me asking my neighbor to watch my car, they owe only a duty of slight care and would be liable only if they were grossly negligent in caring for my car. So a tree falling out of nowhere on my car probably is not their fault. They probably weren't grossly negligent unless they were the one that was cutting down the tree and they took no care into trying to avoid hitting my car with it. Then maybe we have a case for gross negligence. The bailee in this instance would have no right to actually use the bailor's property. They couldn't just take my car out for joyrides unless I told them that they could. And using it without permission could possibly result in the tort of conversion. Flipping the relationship, we have bailments for the sole benefit of the bailee. This is another gratuitous bailment. This time it benefits only the bailee. So the example would be letting my friend borrow my car while theirs is in the shop. So now instead of them doing me a favor, I'm doing them a favor. They need a car to drive while theirs is in the shop. I let them borrow my car, and I'm not asking for anything in return. Now, under common law, their duty of care grows up dramatically. They have the duty of great or utmost care, not to even be slightly negligent in caring for the bailed goods. So if they're driving my car and it gets a scratch, or if they get into an accident and they weren't even being grossly negligent, even just being slightly negligent is enough for them to owe me damages if something is to happen to my property. The bailee may use the property for the purposes for which the bailment was created. If we have written terms, by those terms, if we have an oral bailment relationship here, then whatever those terms were. If they use it for other purposes or for longer than provided in the agreement, then the bailee would be responsible for whatever damages happen. So I let them borrow it just to drive around town back and forth from work, but they take it out to the racetrack and get involved in an accident, something like that, then that would be other for the purposes than we agreed to, or if they tried to keep it longer than I told them they could have it for, they would be responsible for damages again. Now we have a relationship in a mutual benefit bailment where both parties are benefiting in some way. So an example here is when I'm paying a warehouse to store some of my goods for me. So now I'm benefiting because they're storing my stuff for me and I don't have room for it anywhere, and they're benefiting because I'm paying them money. Both parties benefit, thus the mutual benefit name. So now, under common law, the bailee owes a duty of reasonable or ordinary care, not to be ordinarily negligent. So this is sort of a middle road in between the duty of slight care and the duty of utmost or great care. And then in the middle, we have this duty of reasonable or ordinary care. So the bailee would be liable for goods that are lost, damaged, or destroyed due to their negligence. If the warehouse, the bailee would be the warehouse in this instance, if they were negligent in some way and my goods were lost or damaged or destroyed, then they would be liable for those damages. Translating things into the real world, we can modify these terms in the bailment agreement. So when I'm signing the documentation in the contract with the warehouse, they can put limitations on their liability, limiting to a certain dollar amount. And if I want more protection, I have to pay more for it. So these are the sort of the default rules if we don't have more specific terms in a bailment agreement. But it's almost always a good idea to have a bailment agreement there so both parties understand their obligations in this bailment relationship here. Speaking of standard of care, I told you the common law rules. And then states can have their own rules. So it's common in a lot of jurisdictions nowadays where courts just apply the reasonable standard of care to all types. And that's the middle ground standard of care. And they usually just look at the circumstances. Well, under the circumstances, what would be the expected standard of care here? And that's how they would go. So in North Carolina, there was a 1971 case where the court stated that the degree of care required in all cases or all classes of bailments is, in truth, the care of the man of ordinary prudence as adapted to the particular circumstances. The care must be commensurate care, having regard to the value of the property bailed and the particular circumstances of the case. So the court kind of has a fluid definition of what the standard of care is going to be, saying it depends on the circumstances. So they have the ability to go and apply those common law rules. Yeah, you were the one that was benefiting, thus you have a higher standard of care, or, whatever the circumstances will allow there. Okay, so the duration or termination of bailments. So we can set fixed term on them, or there could be no term at all. So if it's a fixed term, that's a bailment for a fixed term. It terminates at the end of the term or sooner if both parties consent to terminating it prior to the term elapsing. And if it's a gratuitous bailment, then either party can just end the relationship whenever they want to, really, again, because there's no consideration for those gratuitous bailments. A bailment at will is a bailment that does not have a fixed term and could continue indefinitely, but then could be terminated also at any time by either party. Upon the termination of a bailment, the bailee is obligated to do as the bailior directs with the property. That usually just means returning it back to them, hopefully in the same condition that it was left to them. It could involve just delivering it to a certain place or just holding it until I get there to get it, whatever the directions are. So now we've discussed ordinary bailments. We'll get into a few types of special bailments, maybe not every special type of bailment, but some of the very common ones. One of them is a warehouse company or a warehouser bailment. So specific rules for warehousing. So a warehouse company is engaged in the business of storing personal property for compensation. So since they're doing it for compensation, that should trigger in your mind that this is a mutual benefit bailment. They owe a duty of reasonable or ordinary care. They're liable only for losses due to their own negligence. And as I stated earlier, they can limit the amount of their liability. Now, this is very important. If you're a warehousing company, you want to limit your liability. If you don't limit it, then it can be unlimited, and that can put you on the hook for a lot of money if something was to go wrong. So you want to understand your risk exactly so that you can properly price things and account for that risk. So on the bailment agreement, you can say this liability, we're liable for damages up to and not exceeding X amount of dollars. And if you want additional coverage, if you want us to be liable for more than that, then you have to pay an additional fee. So you'd have to buy some additional coverage, some additional insurance, whatever you want to call it. So this is just smart business. When you store something in a warehouse, they'll give you a warehouse receipt. This is the document of title issued by a warehouse company stating that the baler has title to these baled goods, and that it includes some key pieces of information like the date of issue, the description of the goods, the amount of the goods, where they're located, and whatever other terms there need to be in this relationship. The warehouse also has a lien on the goods, since the warehouse is supposed to be getting paid. If the warehouse isn't paid, then they can exercise that lien, take possession of those goods, have them sold off to pay what they're owed. And if there's any excess in that sale, then the excess has to be returned back to the original owner. A common carrier, another special type of bailment. A common carrier is a company that offers transportation services to the public. So there's commercial ships, airlines, railroads, trucking companies, public pipelines, companies that hold themselves out to the public saying, hey, we will ship your goods for you. This is differentiated from private carriers. Maybe you have a fleet of trucks owned solely by Walmart or solely by Target or solely by Amazon or whatever. Those aren't common carriers. Those are private carriers, and the rules are different for them. But if you hold yourself out to be a common carrier, there are certain rules you have to abide by. So delivery of goods to a common carrier is a consignment relationship that creates a mutual benefit bailment, because people aren't shipping my stuff for free. They have to get paid in one way or another. The consignor is the person shipping the goods. It's the owner, the bailor. I'm putting my goods in the custody, in the possession of a common carrier. That's the transportation company. They're the bailee. And then it's being shipped to ultimately some delivery place, and somebody else is going to have it. That's the consignee, the person to whom the goods are being delivered. So common carriers have a duty of strict liability. Okay, strict liability means they're liable for these damages even if the loss wasn't their fault. Now, there are some exceptions to that. So if the common carrier goes out and gets into an accident, even if the accident isn't their fault, they would still be liable for the loss of my goods, whatever damages I suffer. And, at that point, it's insurance companies sort of battling amongst each other to figure out who's going to have to pay. But there are exceptions to this. So, and these exceptions will usually be, some of them are under common law and a court would interpret them. Some of them are stated directly in the document that I would sign, the bill of lading, to figure out what the exceptions are. So common exceptions being acts of God. So, things like lightning strikes, earthquakes, floods, stuff like that. The public enemy, if there are riots or terrorist attacks or something like that. If the government intervenes in some way and makes something illegal or something happens due to government action. If the shipper is the person who messed up, like you didn't adequately pack those goods to where when they're moved around, they just get damaged within the box, then that can be on the shipper and the common carrier wouldn't be liable, or just due to the inherent nature of the goods. If they're so fragile or if they're perishable goods and they just degrade over time, there can be exceptions to the duty of strict liability for a common carrier. Common carriers, like warehousers, can limit their liability, and smart ones will, to a certain dollar amount, as long as they offer additional coverage for a fee. So we insure up to $500. If you want additional coverage, you have to buy additional insurance to cover the gap. And then the fee can vary according to whatever the value of the goods is. You might be familiar with this if you ship them something through the post office and it's something that's very valuable and you don't want to risk losing it and losing the money if the package gets lost or damaged or destroyed or something. then oftentimes you say, well, the post office will insure up to X amount of dollars. And if you want more than that, then you have to purchase the additional insurance on that. So a lot of you probably have encountered that just in your general life. A bill of lading. So instead of being a warehouse receipt, you would get a bill of lading here when we're dealing with common carriers. This document says just the terms of the relationship. So whatever the terms are. The carrier, like warehouser, has a lien on the goods in its possession that are covered by a bill of lading. So I'm paying this carrier to ship my goods. If I don't pay them, then they can take possession of those goods, have them sold, auctioned off, whatever, to recover their fees that are owed to them. If there's any excess that they gained in the sale, then that would have to be paid back to me, the original owner. An exhibit, if you're having trouble visualizing what this might look like. For most people, it's pretty intuitive, but if you haven't dealt with it before, then maybe not so. So we have a shipper who, and then we'll give them all their names. So the bailor, so they're the person that owns the goods here. They're also the consignor in the common carrier relationship here. They transfer possession of goods to shipment to the common carrier. The common carrier is now the bailee. They don't own the goods. They have possession of them, and they have a duty of care to try to protect those goods and get them delivered where they're supposed to be safely and damage-free and on time, hopefully. So they ship the goods off to who's going to be the ultimate owner, the consignee, and so that's what it looks like. There's a whole different discussion about when title to those goods actually transfers. When does it transfer from the shipper to the consignee? And it has to do with the terms of the deal. And I was having trouble remembering the terms, but things like FOB terms, there's different terminology, FOB, CIF, CPT, CIP, FAS. There's all sorts of terms that are in common usage in the industry that indicate where the actual title or ownership of the goods transfers. Is it when you put it on the truck? Is it when it's actually delivered? It depends on the terms of your relationship. Okay, so an example here, Excel Incorporated versus Southern Refrigerated Transport, which from here on out will be abbreviated SRT. This happened in the U.S. Court of Appeals for the Sixth Circuit in 2018. So we have a pharmaceutical company that hires Excel to coordinate the shipment of drugs. Excel then hires SRT to transport the drugs. Somewhere along the way, SRT's truck is stolen and all the drugs are gone. The value of the drugs, if we were to sell them, was $5.9 million. SRT tries to claim that there was a term on the bill of lading, RVNX, that would have limited the liability to $56,766. So this is quite a gap here between $56,000 to $5.9 million. There's a lot of room for argument here. Now, SRT says that the RVNX term meant return value not to exceed. So if this is a common industry term, and if it was properly stated in there, then perhaps they have limited their liability to this $56,766. But looking at it, the court said this was not an industry recognized term. Nobody was really quite clear what it meant. It wasn't clearly stated on the bill of lading, so Excel really didn't know what they were getting into there. So since we didn't have this meeting of the minds here, then SRT was on the hook for unlimited amount of damages, which would have been that $5.9 million. So lesson here, to be very careful about your terms, especially when you're dealing with large amounts of money or highly valuable goods, to make sure everybody understands the nature of this relationship, what's covered and what isn't. All right, the last one that we'll talk about is the innkeeper. the last kind of special bailment that we'll talk about in this lesson here. An innkeeper is an owner of a facility that provides lodging to the public for compensation. So we're thinking hotels and motels here generally are considered to be innkeepers. And then you can make an argument. So now translating it into modern terms, making an argument for if I have an Airbnb, would I be considered an innkeeper? The laws regarding that can differ state to state. So an innkeeper has a duty of strict liability, meaning they're strictly liable to transient guests for personal property that is lost or stolen from the innkeeper's premises, even if the loss was not the innkeeper's fault. So that's the common law rule. Then what we have to understand, as we'll see on the next slide, is that states are allowed to pass their own statutes to limit that liability. If there isn't a state statute, then the innkeeper could potentially have unlimited liability. But there's lots of things that come in to complicate this relationship. I also have a contract that I'm going to sign with the hotel, and maybe that contract limits the liability to certain dollar amounts. So there's a lot goes into it here. I'm just giving you a default rule. The default rule is the innkeeper is strictly liable for property that is lost or stolen. We also define a transient. This is just a guest whose length of stay is variable. It's important to distinguish between transient guests versus tenants in a landlord-tenant relationship and understanding what the relationship is here specifically. So, a landlord generally is not going to be responsible for personal property of a tenant, but an innkeeper could be. Okay, just like I said, states can pass innkeepers' statutes that limit the common law liability for their guests' personal property. An innkeeper can avoid liability for loss caused to a guest property if they provide a safe where valuable goods can be kept and the guest is notified of the safe facility. And then the hotel can also set their own liability limit and then notify guests of whatever that liability limit is. So this is pretty common. So if I'm going to a hotel and if I have very valuable goods, whatever it be, jewelry or whatever, a lot of cash, whatever it might be, I need to have a discussion with the hotel to figure out how to keep this property safe. Maybe there's an actual physical safe in my hotel room, and I need to understand what the liability limits are for property that's stored in that safe. Maybe there's another safe down at the clerk's desk or somewhere with hotel management where I can keep very valuable stuff. I might have to pay an additional fee if the value of those goods exceeds some type of limit. So it's really on me as the customer here, as the guest, to do my due diligence to make sure if I want this property to be insured and covered by the hotel or by the motel, wherever I'm staying, then I need to do some work to try to figure out what are those liability limits, what do I need to do to make sure that my property is covered in the event of things like it being stolen, if somebody breaks into my room and steals it, or if there's a fire and damage is caused and it's the hotel's fault for the fire, things like that. I need to make sure that I understand so that I don't get stuck with a huge loss on my end because I didn't understand the nature of the relationship. Now, I gave you a link to the North Carolina innkeeper statute there. You'll find that the liability limits for innkeepers are rather low. It can be anywhere from $100 up to about $1,000 per statute, just depending on what's going on, what type of property it is. And that's not that much money. So if I have very valuable stuff, maybe I need to have a conversation with the hotel. That's it for this lesson. If you have any questions, feel free to reach out to me. I'll do my best to help. Otherwise, have a fantastic day.